tort panel. I'm sure Stuart is the one who comes up with all these great puns. At BICA's 25th Annual Business Forecast Conference. My name is Coby King, and as of this past Tuesday, I am the President and CEO of High Point Strategies. I'm also the Chair-elect of VICA, and I'll be moderating the panel this morning. I want to thank our track sponsor today, Walmart, and our panel sponsor, the Civil Justice Association of California. So thank you to the two of them. At your seat, there is an exit survey for the panel. I believe it's the green slip. Please locate it. We really, really want your feedback. We actually do look at these forms every year, and we make adjustments as necessary. So please turn it in to VICA staff or a VICA ambassador at the back of the room, or you can turn it in at the registration booth in the foyer. We really do need your feedback and appreciate it as well. The goal of this panel is to discuss whether tort reform is needed in California. We have a really great panel lined up. The biographies of each of the panelists are already in the journal book that you all received today when you registered. So I'm going to make very, very brief introductions so that we have more time for your questions. Immediately to my left is Caryn Brottman Sanders with the law offices of Caryn Brottman Sanders, and she's also president-elect of the San Fernando Valley Bar Association, so we share taking on a new responsibility. And then sitting next to Caryn is Lisa Maki. She's the founder of law offices of Lisa L. Maki and the chair of the Consumer Attorneys of Los Angeles. Then, and then to her left is Kimberly Stone, president of the Civil Justice Association of California. And then finally, my good friend, California State Assemblyman Mike Gatto, representing Assembly District 43. Are we in the? I believe we are in the district. So we're constituents for a day. I'm going to give each of the panelists a couple of minutes to make an opening statement, get things started, and then we'll ask some questions of each of you, and then we'll open it up for questions from the audience. And I know we have two microphones here, so so that everybody can hear. Let's just make sure that we speak into one of the mics. So, Mike, I said we would start with you today with some of the tough questions, but you've now been in the Assembly for a few years. What can be done to curb abusive Prop 65 lawsuits that impact small business owners?
Well, everybody, that is what is called a softball question. I'm Mike Gatto. I represent the 43rd District. District starts in the Los Angeles city communities of Hollywood, Silver Lake, Los Feliz, and continues through Burbank, Glendale, La Cañada, La Crescenta. This year, I had one of my constituents who had been subject to a meritless Prop 65 lawsuit threat. He is the owner of the Coffee Table. It's a really popular small cafe in the Eagle Rock neighborhood. He has been there for 14 years. He serves, primarily coffee, but he also does have beer on his menu. And he got a letter from an attorney who, said, my client has been coming into your shop for every day of the last 14 years. He has ordered a beer every day the last 14 years. And meanwhile, the guy's thinking, well, gee, I've been here every day the last 14 years. I've never seen this guy. But, and he said, you have failed to warn him that beer can cause cancer, and therefore we are going to, you're liable for $2,500 a day retrospective penalties. And the guy freaked out, and he called his landlord and said, I'm leaving California. I'm out of here. One of those stories that we hear quite a bit. And the story got to me, and I appointed this guy to my Business Advisory Commission. It's a commission I have of small businesses in the area who advise me on issues that businesses are facing, and they unanimously voted to get me to carry legislation on this very topic. And when they voted for that, I thought, oh, great, Prop 65, it passed by the people. It takes 2/3 to amend it. It has never been substantively amended in the almost 30 years it's been on the books. Thanks for setting me up to fail. But we were able to introduce something that I think was a sensible fix. I worked with, or my staff worked with everybody on this panel, and we were actually able to get the various different sides on this panel to agree on something. And I told my staff that they're next going to Israel to broker a deal between the Palestinians. But we got something, a product that was sensible, and it basically provides businesses who sell really common, common products that contain common chemicals. It provides them a fix-it ticket, a safe harbor where, if someone says, hey, you don't have a sign up, they can put the sign up, and because that's the goal of Prop 65. And the bill passed with the supermajorities needed, bipartisan support through Sacramento. It sits on the governor's desk. I was just talking with Kim about, we're hoping and praying that he signs it. To us, it was a no-brainer, but I think that's something we can do. It's a sensible fix, and I am a member of the most popular profession. I was a lawyer in my past life, and so I see both sides of the issue, but this, I think, was a sensible fix, and hopefully one that is bringing some relief to area businesses. Thank you.
All right, so I've been moderating these panels now for many years, and
Too long of an answer.
well, no, it was a great answer, Mike, but I made a mistake, and I apologize for that. I didn't give people an opportunity to talk a little bit about themselves. So, Mike, you want to add anything to that, just in terms of what you've been doing?
No.
Okay. All right, Kimberly, let me make amends, give you a chance to introduce yourself.
I run a nonprofit public policy organization in Sacramento called the Civil Justice Association of California. We try to fight against unjustified excessive lawsuits. I am a lawyer, but I don't represent clients. I run a trade association. So, for example, if you would contribute to the Sierra Club because you were a supporter of the environment, you would contribute to CJEC if you thought that California had too many lawsuits. One of the things that I want to share with you this morning is the extent to which excessive lawsuits and unjustified lawsuits affect all of us every day. And I just want to ask a question here. This is a warning label on a product that many of you have purchased recently. And I'm going to read it to you and see if anybody can guess what the product is. Combustion of this manufactured product results in the emissions of carbon monoxide, soot, and other combustion byproducts which are known by the state of California to cause cancer, birth defects, or reproductive harm. Cancer, birth defects, or reproductive harm. Does it sound like a dangerous product? Matches. Matches. Combustion of this manufactured product results in the emissions of carbon monoxide, soot, and other combustion byproducts, which are known by the state of California to cause cancer, birth defects, and reproductive harm. Now, I get a little bit excitable about things that seem to me sort of silly as a result of some of our unjustified lawsuits. There's a number of warning labels on other products which insult our common sense. One of my favorites is a foldable baby stroller, which Stuart and his wife might buy soon. They're really cool. Like, you fold them up, and then you can wheel them behind you, and then you put the kid, not like the big kind. Those ones say, remove child before folding. There is a globe, so don't forget that. A globe saying that the globe should not be used for navigation. Electric razors and hair dryers advising you not to use them while sleeping, and irons suggesting that you remove your clothes before ironing them. We have had lawsuits in California against Fruit Loops for not containing real fruit, any fruit. And one recent lawsuit against a video game company for discontinuing the 2008 version of the NFL Madden game in place of the new version because some of the players left. Man sued Apple Computers after becoming addicted to pornography. Frequent flyer mileage lawsuits against airlines for not containing the vertical miles as well as the horizontal miles and distance from place to place. And not all of them are funny. Like, a lot of them lead to businesses suffering hundreds of thousands of dollars in damages, or small businesses suffering thousands of dollars to defend themselves. We have Prop 65 lawsuits that are enforced by individual lawyers who have the ability to get attorney's fees, Americans with Disabilities Access lawsuits over very minor technical violations. Neither I or my organization thinks that all lawsuits are bad or that all lawsuits are inappropriate. If somebody has genuinely suffered harm or damages, then by all means, one of the great things about our country is that they deserve appropriate and fair compensation. Our courts should be fully and appropriately funded, which is one of the things that I suspect the plaintiffs' lawyers on the panel and I agree on. But I do feel that California, in many cases, has gone too far in a way that costs all of your businesses money in terms of increased insurance costs and increased vigilance. And I'll be happy to talk more about that later on.
I'm sure you will. Lisa, I want to thank you for entering the Lion's Den. And why don't you... Here you go.
Hi, everybody. My name is Lisa Maki, and I'm a trial lawyer, everybody. So I mainly practice in the area of employment law, and I'm also a small business owner. I own 3 small businesses. So I'm not really in the Lion's Den. I'm here with you guys. A couple points I wanted to just talk about briefly or bring up. Number one, there's always a lot of press that's out there saying California is the worst place to do business. You know, lawsuits are the number one problem. Excuse me while I put on my glasses. And in reality, it's not that bad. It's not the number one state where there's all these so-called frivolous lawsuits. And if you're at the next panel, Mr. Kabatak, who is with the National Federation of Independent Businesses, according to his statistics, when you survey the business owners, it's actually, according to the business owners, out of 75 issues, it ranks 71. It's the 71 most serious problems. So there's, 70 other more serious problems before that. In California, 70% of the cases are basically less than $25,000 or small claims. The other thing is 7 of the 8 largest verdicts in California last year, so that would be 2012, were won by either corporate or government plaintiffs. The year before, it was 7 of the 9 largest verdicts. I always hear all the press, and I grew up in Nebraska where no one sued anybody, okay? My parents are, what? I think I knew that. But you don't, my sister got mowed over by a car, and it was like, oh, well, all right, she'll be okay. I mean, it was very different. Times have changed. It's a part of doing business now. I've been sued. I've been sued more than once, and I get it. And I didn't like it, okay? I can talk later about ways to protect yourself and your business. I get, this drives me crazy when people talk about frivolous lawsuits. Sure, there's frivolous lawsuits. There's frivolous lawsuits filed by businesses, by the government, all sorts of things. But the reality is, if I'm working on a contingency fee, if I'm not going to get paid until the case is done and I actually win something, I am very, very, very careful about the case I file. I am not going to waste $1 million in attorney time and costs that I get to front to file a bullshit case. And yes, I swore. Here's the other thing, you guys. What people don't realize is before a case hits a jury, and I'm talking about California state courts, the person who brought the case is subject to basically 3 different types of review to throw the case out. So, if a case gets to a jury, there's some kind of merit there. Most cases settle. Most of them settle. Most of them do not go to trial. The ones that go to trial are kind of the crazy ones, all right? They're usually not that great for the plaintiffs. And sometimes you'll see someone who gets very mad at the defendant, and that can be a person or a corporation, and there may be a high punitive damages award. Well, guess what? We don't get punitive damages anymore like we used to. It used to be unlimited, so you'd get these crazy, like, $80 billion punitive damages. Now, they're very limited. we generally cannot get more than 3 times the special damages. So, for example, let's say I'm representing someone who was raped, which does happen, believe it or not, by a supervisor at work. Her special damages, meaning her loss of income, her medical bills, are $20,000. I'm going to probably be limited to right around $60,000 in punitive damages. So that's something that has happened and decreased the whole punitive damages issue in California. And I'll just make a couple other super quick points before you.
You know what? Why don't you hold those?
Okay.
Hold those, Lisa. Well, I think
Sorry.
we'll have time for some of that. Caryn, you want to introduce yourself and give a little perspective?
My name's Caryn Sanders. I have been practicing for 19 years. I do plaintiffs and defense work, so I may be sort of the middle of the road person here at the table. I also do work in both personal injury and malpractice. And so I see sort of the conundrum with tort reform, because in California, malpractice has been the subject of tort reform for almost 40 years. And the issue becomes, is there a happy medium? Because the limits in malpractice are very, very low, and they haven't been changed in almost 40 years. However, if you can, which lawyers will do, and I have worked the case from both sides, maneuver it into a different type of case, some type of personal injury or product liability, you can avoid the cap that medical malpractice has, which sometimes makes for some very contorted cases. The other aspect is, yes, you hear about them all the time, the people who want access or sue under the ADA for different access. And unfortunately, you've got the people who actually do want to frequent a business and do think they need access and should have a right of action for that. But then you also have the people who do run around creating cases. They go and find the businesses they can't get into, and you will see, because I get them every single day, the filings in LA County, and you'll see one lawyer that files for the same plaintiff against 17 different businesses for lack of access. There has to be, and I'm not saying I have all the answers, but some type of happy medium between that and the people who truly have been affected by a lack of access or a lack of justice because of a cap that's too low, or a lawyer who won't take a case because a cap is too low. And so that's where tort reform needs to come in. There needs to be, in my opinion, some type of more uniformity, so you don't have the one type of personal injury which could be far more severe than another type of personal injury, but they can't recover because California says they can't recover more than $250,000. And usually what we're talking about is their non-economic damages, or what people call pain and suffering. Economic damages have not been capped. If you truly have medical expenses, you truly lost income, or you'll never be able to work again, those are not what usually is directed at tort reform when you're talking about the damage recoveries. It's the non-economic, the pain and suffering. Well, if you've been paralyzed due to a medical accident, medical negligence, or you've been paralyzed due to a car accident, one of you only gets up to $250,000, and one of you could get several million. That's what I see as the biggest problem with tort reform in California.
So, Caryn, how would you, if I could ask you to speak to your mic, can't hear you, but because we want to make sure we capture everything for posterity. What would you change if you could today in the California judicial system? Be curious on other people's opinions on that.
Well, for me, first of all, I would raise the cap on medical malpractice. I think that just for inflationary purposes, a dollar number that hasn't changed since, I believe it's 1975, is ridiculous, to say the least. I would also be very interested in making some type of uniformity between a personal injury recovery and a medical malpractice recovery. And by by that meaning if you're going to cap the same type of injury at $250,000 because it's medical malpractice, then it should be capped at $250,000 because it's personal injury. And before everyone starts jumping up and down, I don't think $250,000 is the right number for either. But I do think that one of the biggest issues with tort reform is making it more even, making the playing field more even, so that no matter what you title a case, your chance of recovery is the same. Or no matter what caused your injury, your chance of recovery is the same. And the other issue is you have to protect the right of access for people who have been truly harmed. So to say we can no longer have any ADA lawsuits, I don't think is accurate. I don't think that that serves anybody, because there will be businesses that just don't see the point of having a handicapped parking space or a ramp into their front door. But people need access to businesses. And then you have the business complaints, and I represent a lot of these people who say, okay, but do we need 17 handicap parking spaces when we only have 34 total? That's an exaggeration because it is mandated based on the total that you have. But so there's a lot of fine tuning that needs to be made so that it's more equal.
Thank you. Lisa, any views on if you were running the show in Sacramento, what adjustments or changes you might make?
Sure. Well, if I were president, no. I think I hate the idea of capping. I mean, I don't know if you remember, I'm a lot older than most of you guys, but way back when I was in Nebraska, there was the conservative folks that I know now are very different than the ones back then. It's like you would never, I was good friends with Al Simpson, who's a very conservative senator out of Wyoming way back when, and we had some great debates. But one of them, and something we really agreed about, is, this is America. You don't cap anything. It's like, you want to cap damages? Okay, fine. Then cap the CO's salary. I mean, this is a free market, and I don't think anything should be capped, because then you've got to go, well, then why doesn't this have to be capped? Why it just doesn't philosophically make sense. If you're a business, let's say another business does something illegal to you and takes all your business, do you want a cap on what you can recover from them? No, you want the full amount, whatever that amount is, and it may be over the cap. So, obviously everybody, not everybody, but a lot of people dislike the plaintiff's bar because of, and I know the gentleman that you're speaking of, there are attorneys that our Los Angeles trial lawyers group and the state group actually work to do something about. The people that are filing the multiple, what we call drive-by access cases. That is horrifying to me. It's degrading to the business. It's degrading to the disabled community. And we actually work against that. That is not something that our groups are in favor of or support. And we do not like those attorneys either. That is not right. That's not what the system is designed to do. There have been changes in that law too, where there's a waiting period and things like that. Couple things I want to bring up related to the other comments, and I see this more and more in employment cases than anything. I mean, there's been a rise, I think, in employment lawsuits by employees from what I've seen. And here's what I get all the time. Okay, I've got a case, and we help people for free. Okay. So this person is owed, let's say they didn't get their last paycheck, and I call the employment, or I call the company or the lawyer, and I go, look, you didn't pay him his last paycheck, and he's owed this much in overtime. Can you have your lawyer call me? So I get a call from the lawyer. I'm like, look, this is all we want. I'm not going to take a fee on this. This person needs their money to pay their rent, or they're going to be on the street. They now don't have health insurance, so their disabled kid is not going to get the cancer treatment, so he needs his money to pay for the COBRA, which is usually double what the employer paid into the insurance program. And yeah, they have pre-existing conditions, so they can't have insurance, and she really, really needs to have her cancer treatment. So here's what I see. The defense, no, we're not going to do that, and we're going to fight you to the end, and and by the way, they were stealing on the job, and there was a bomb threat, and they were sexually harassing something. I'm like, what? Okay, well, all right, that's fine. We disagree, and by the way, that might be defamation. So then we're like, look, this is all we want, just the overtime. Give him his last paycheck. No, file the lawsuit. So then there we are. We've made a very reasonable proposal, and then we're in litigation. Employment lawsuits are very, very expensive. And what I see a lot, and there are a lot of good defense firms, I see a lot of overbilling by defense firms. The market crashed for big law, 2008, 2009, 2010, and so they just grab on because they can bill all you guys by the hour when we're on the other side going, look, this is all we want. Can we talk? Can we sit down? No. So look at your attorney bills and look what they're doing on your employment cases. Another very important thing to do if you have a business, and I don't care how big or small it is, you need to get employment practices liability insurance. It will cover the defense of and a lot of the damages in employment cases. It's very cheap, and you can add that onto your workers' compensation policy. Very cheap. I would never go without it. That's it.
Kimberly, I'm sure you have a slightly different perspective.
Yeah, so I could talk like all day about this, but I won't. And I wrote down 5 areas in which I would love to see California's tort reform laws changed. One of them is class action reform. I don't know how many of you, like this week, have gotten postcards in the mail where you are a member of a class against a company that you probably never had a problem with, and there's a lawsuit on your behalf. And when that lawsuit is resolved, the lawyers in that case will get millions of dollars, and you will get, I don't know, a coupon worth 75 cents or something like that. And California public policy class action law favors class action lawsuits, and we have among the most developed and friendly law to plaintiffs in consumer class action lawsuits, and that's why you have these ridiculous cases like Fruit Loops doesn't contain fruit, or I bought Listerine and my breath still smells bad, or it's not as good as brushing, or I wore sunscreen and still got sunburn. Ridiculous kinds of cases. The other recommendation I would make is that both sort of building on Assemblymember Gatto's bill that would allow restaurants and bars to put up a sign if they didn't have one to fix the problem before getting sued. I would extend that to all Prop 65 lawsuits and all ADA access lawsuits. The reason that we don't have full compliance with the Americans with Disabilities Act is because when it was passed, there was no government enforcement of that. Like all the other rules and requirements on businesses that are enforced by some inspector who comes out and doesn't license you or gives you a ticket if you don't do it, if you fix that problem, then you're not in trouble anymore. And we have great compliance. We have compliance with earthquake codes, with fire codes, with safety codes. But because the ADA was set up that enforcement was through individual lawyers with the ability to get attorney's fees, that's why we have these abusive lawsuits. So I would go back and get rid of every individual enforcement mechanism in our laws by private attorneys and put it in a governmental body instead. I would significantly change our employment laws. I hear vastly different sides of the story than the one that you just recommended, where it's very difficult for employers to fire employees for things as basic as not coming to work or not performing on the job, and that they feel really trapped by California's employment laws. And I would make them more reasonable. And if somebody doesn't show up to work and doesn't tell you why, you should be able to fire them. And just so you know, if you do fire someone, you have to pay them their wages that day. You can't wait for the rest of the payroll. So you need to, just because that's a frequent thing that happens that people get sued for. So if you fire someone, you pay them their wages up until that point, at that point, and give them, get their key back and be done. And then I would also recommend changing the timelines on summary judgment, which is a technical kind of boring issue that I won't go into here. And that's it for my top 5.
Thank you.
Society's got a lottery mentality, so when you've got enough money, no matter how privileged the lawsuit is, like the San Diego attorney got sued 17 times on 17 different properties for ADA complaints. They were ridiculous, 12 from the same guy. Okay, it was extortion, but the world is not wrong.
So, Assemblyman, this is an issue that you hear over and over again. One is the issue that the gentleman is referring to, kind of abuse of the system, and then secondly, the big hot issue, and maybe we can talk about these separately, is the controversy over the medical malpractice initiative to change the law capping that. Thoughts on either of those from the perspective of the legislature?
Sure. So I'm happy that that Tony piped up now, because I was going to, during my answer of the question you posed about what should government, I mean, if we were running things in Sacramento, what should we be doing? Yeah, and I was I figured at some point the mic would come to me, and I could give my perspective on that. For what it's worth, I mean, I consider myself a small government Democrat, and I know there's some people who say that's an oxymoron, but I mean, I'm mindful of the fact that government can't legislate away anything. I think both panelists have alluded to that. I mean, there's just something we can't do about the unethical people in the legal system, and I'm going to talk about the things we can do. But if there's somebody who's that clueless kind of business owner who sexually harasses an employee, is really pushing on a female employee, and then gets sued and says, "Oh, I didn't do anything wrong." I mean, there's only so much we can do about that guy who is so clueless, and yeah, there you go. Yeah, happy for once I had nothing to do with that, but and on the same side, there's only so much we can do about the unethical person who sues all the time and really abuses the system. But there is a lot I think that government can do. Real quick show of hands. I just want to know how many people in the room have actually been sued. I'm not talking if you're an attorney, if you've been on a defense side, but how many? Okay, so we've got a number of people who've been sued. How many people have sued somebody, even small claims? The thing, if you picture back when you were sued, you had to hire an attorney most often, and the attorney was expensive, and attorneys bill by time. And the old adage, time is money, really, really, really applies in those cases. I mean, and if you think back at the people, how about the people again who sued someone? You mind me picking on you and asking you what it was? Okay. Yeah, okay, great. So, when you sue someone, you want your money fast. I mean, again, assuming most lawsuits are valid, if somebody hits you and they're not paying, and you've got to repair your car, and you're a working guy, working gal, you want your money fast. And one of the things that I think we really could do in Sacramento, and we have done a terrible job at it, and I'm happy to tell you my opinion why, but the court system is woefully underfunded right now. The court system is a third branch of government. Everybody knows their civics. At the peak, at 2007, when the budget was really good in California, the court system was 2% of the budget. A branch of government was 2%. It has now been reduced to 1% of the California budget. My opinion on the reason why, California is a very initiative-happy state. We're only one of 25 jurisdictions in the United States that have initiatives to begin with. Just jurisdictions like Texas don't have them at all. Even New York doesn't have initiatives. In California, there has been a ballot initiative protecting every major source of funding in the state budget, except for two: higher education, that's right, UCs and Cal States, and the court system. So, there's been a ballot initiative that protects mental health facility construction funding. There's been a ballot initiative that protects the prisons. There's been a ballot initiative that, every part of the state budget is so spoken for that, these other ones keep getting cut. But we've got to do something about that, because when you sue or when you get sued, you want the thing resolved quickly. And a lot of the pain of frivolous lawsuits would go away. Well, not all of it, but a lot of it would go away if you didn't have to pay a lawyer for so many years to get justice. The other thing we can do, and I think Tony made this point, and he made it really well, we've got to crack down on people who abuse the system. I mean, I've been heartbroken, California's going through a budget crisis, but we have cut the people who investigate fraud in Medicare. Well, so what message are we sending on that? We're sending that, our society will tolerate it. And I agree, when there is an attorney who breaks the public trust, because they are officers of the court, we should have a robust enforcement system. Because, I know a lot of people like Lisa, and Lisa is right in what she said. Most attorneys who are on the plaintiff's side, they do not sue unless they think they have a good case. There really is a demographic. I mean, the guy in my instance with the guy in the coffee shop in my district, he was going around sending 20 or 30 letters a day to CPK, to this restaurant, to that restaurant, to this restaurant. Lisa would never be caught dead doing that.
Okay, but Assemblyman, why can't the legislature figure out a way to stop that kind of behavior?
We have, like so much else in the United States and in California, it's an issue of actually enforcing the existing laws. I mean, I know people who've been disbarred. The thing it takes to get disbarred in California, I mean, you literally got to be stealing from a client to get disbarred. Filing a gazillion frivolous lawsuits, being sanctioned, I mean, it's a pretty high bar to get disbarred. And that was a bad pun. But I mean, we really need to enforce the law. And I think to enforce the law, we need more state bar enforcement examiners, and that costs money. And, yeah.
Kimberly, go ahead.
So those, I'm glad that we're all hating on those ADA lawyers together that go around and do that, but they're not breaking the law. They're not doing anything that is not perfectly permissible and allowed under California laws as they stand. There is no reason, sadly, for them to be disbarred. Most small businesses that I frequent are not fully ADA compliant. Most small business owners do not know how to make their businesses fully ADA compliant. The rules change every single year, and there's a booklet put out by the federal government that's this thick, and by the state government that's about a centimeter smaller that's this thick, and every establishment that serves any members of the public is required to comply with all of those rules. And in the cases where the two conflict, you are held to whatever is the higher or more accessible standard. I recommend that businesses that serve the public do an annual audit, which is an evaluation by somebody called a certified access specialist to find out if you are compliant or not, and in the areas where you're not compliant, to go ahead and make the changes. I recommend you have your lawyer request that certified access specialist report so that it doesn't become discoverable, meaning you have to give it to the other side in the event that you are later sued before you become fully compliant. But the thing about it is we set up our rules in the state to allow and even encourage these kind of lawsuits by allowing violations of up to $3,500 per day per violation, plus the prospect of attorney's fees. And while I agree with much of what the Assemblymember said, there's political forces at work that prevent the legislature from making changes that would allow ADA and other Prop 65 lawsuit defendants a chance to fix the problem before they were getting sued.
Say, Mommy, what do you want to be when you grow up? I want to be a certified access specialist. I mean, it's amazing. It's amazing the professions that surround a lot of our judicial staff.
All right, why don't we see if we have any questions from the audience? Anyone have? Yes, sir, right here. Why don't you introduce yourself and then ask your question?
and if I may, I just want to say, Drew, I think you make excellent points. I was going to joke at the beginning. I'll disclose now. I'm a middle child, right? So, I try to see both sides of the story, and the only thing that I would point out though is if you are one of the 5%, or you're the target of one of the 5% of bad lawyers, you got to put yourself in that person's shoes though too, because when you are being sued, when you are going through one of these painful, unjust lawsuits, it's cold comfort that 95% of lawsuits are valid. But that being said, you did raise a very good point. I mean, there is so much that has happened in this country, whether you look at, Pintos exploding, or, that really people would not have been aware of unless there were lawsuits. I'll tell one quick anecdote that really, I think, illustrates this. I used to practice at a big firm, and at a big firm, you do mostly defense stuff. We did some plaintiffs' work. We did mostly defense stuff, but I was on a case once where it was a class action lawsuit about cell phone service, and it was there was a cell phone company that the allegation had been that they had not built a network at all, and yet they were signing up customers in an area where they didn't have a network, and and it was a pretty big case, and we were once then driving to court, and I was driving the car with a partner, and we had both talked about how it stinks, this suit stinks, blah blah blah, and she kept trying to make a call, and her phone kept going out, and she started cursing, and and it was really just a poignant moment. I mean, here we were defending this case, and of course, how many people in the room like their cell phone companies? So yeah, I agree. I think there tension. This is America, and we have an adversarial system, and it's very important to have both sides.
And Drew, I would agree with you and urge you to try to work with us, because what we find in the legislature is that my organization could run a bill saying every day ends in Y, and the trial lawyer lobbying group would oppose it. Just, you know what I mean? I could sneeze. Well, she's not the one. Like, these aren't the. I mean, there are reasonable trial lawyers. No. There are reasonable trial lawyers, just like there are reasonable business owners. There are business owners that behave badly, which is why we have these ridiculously restrictive rules for the businesses that don't behave badly. And I do believe that on both sides of the argument, there is room for common ground, a great deal of room for common ground. And I wish that that I saw a political way to get there.
It's called the underground economy, and because I'm from Nebraska and all that, I mean, I see companies that are paying everybody in cash, okay, that are 1099ing every single employee, that don't have workers' comp insurance. I mean, it makes me want to cry, because then some of these people get hurt, they break their backs, they're doing really hard labor, and then what? They go on the public dole. You guys pay for that. I pay for that. And so a lot of the work I do in the cases that I'm bringing against employers aren't like against your kind of businesses that are operating legally. These are the scumbags that aren't paying taxes, that are paying everybody cash, so that we have to pay more. And that's why I feel really good about what I do. And I agree. I mean, really the problem is really money, and no offense to the Honorable Mr. Gatto. I mean, legislators are in a difficult position because they have to run around like most of their time and fundraise, okay? So they've got to get money from everybody to get reelected, and it's very hard to be, honestly, pure if you're a legislator when you've got, you've got to really make a lot of people happy. So if we got rid of that, and now that the U.S. Supreme Court has said that corporations are persons, corporations can basically dump unlimited money into political campaigns. Well, of course, if I'm a legislator running for office, who do you think I'm going to legislate for? There's been massive class action reform, you guys. You have no idea. I mean, class actions are basically non-existent anymore. And I can, if you want to email me, I'll send you all the cases. I'll walk you through why. There's a very important purpose in class actions. No one likes those pick and run ones. I don't bring those kind of cases. I don't like them. But it's a very important vehicle to have if it's used properly. You know, I think we're all in agreement. We don't like these attorneys, this very small group of attorneys that's running around doing crazy stuff, but they don't usually last too long. The state bar can only take complaints from clients. They can't take them. They can't do anything about the public. You know, and yeah, I mean, it'd be great if government had all this money to run around and regulate and make sure that all the, you know, the ADA, that the government could run around and look into all that, but they don't. We don't have the people. You know, I mean, the Department of Fair Employment and Housing has been completely defunded. That's a state agency. They can't investigate. They can't do the things that they could do to try and resolve some of the employment complaints beforehand. So it's like no one likes big government, but, you know, I think what everyone's saying is like we need this, we need reasonable regulation that'll work, you know, and what my hope is, and always in the future, is that, you know, whatever side you're on, that we can sit down and come up with some kind of reasonable compromise, because that's the only thing that's going to keep this country going forward. On a real positive note, I see the economy improving because I get a lot of, I represent a lot of people who are terminated, and it used to be, you know, maybe in 09, 08, 09, they would not get another job. I mean, we knew, especially if you're older, I mean, you're just pretty much screwed. So we knew these people would be out of work for a year or two, or maybe never get a job again. It was that bad. Things are looking up. The people that I'm speaking with and I'm meeting with, they're getting work sooner, and that, to me, is a very positive factor. One last thing, if you are an employer, you would not believe the kind of calls I get, like pretty much crazy. I've gotten calls from people like, I had to wait in line and I want to sue. Well, we spend most of our time talking people out, and businesses too, out of bringing litigation, and to sit down and talk like adults. A lot of it becomes emotional. I have, and I know because I'm a little hot-headed, a lot of it is like, F you, you know, I'm going to sue you, or F you, I'm not going to ever settle this case. I am going to money you to death because you're just a little minimum wage worker. You know, so a lot of times we have to put our emotions aside and come up with a reasonable solution that's good for everybody. And if you are an employer, you know, really pay attention to your employees. You would be shocked how many people that say, you know, I would never be calling lawyers if they would have just said thank you. We are, what you don't realize, we're an at-will state. You can fire someone for any reason with or without cause. We are not a right-to-work state. There is no contractual agreement in employment. And what I do, and what I, you know, when I do talk to business folks, you know when someone's not, it's like dating. Like, you kind of know, right, after like 3 dates, or, you know, maybe 2 or 1, hey, this isn't going to work. Break it off. Don't wait around like for a year or 2, and then the person thinks they're doing a great job. I mean, when I, you know, yes, I fire people. I mean, I've got businesses. I do it right away, even if I get a bad vibe, because I don't want to lead anyone on and think they're doing a good job. I tell people I don't.
Up at a rate greater than inflation since 1974. So the overall amount, if you look at the numbers that plaintiffs get in medical malpractice cases, has increased at a rate greater than inflation since then. The only part that hasn't increased at a rate greater than inflation is the small part, if I had a bar graph to show you, the small part of the bar graph that is maintained constant for that $250,000. So it's not that victims of medical malpractice are being undercompensated overall. It's that one section of it. And the reason that we're talking about this so much is that there's probably going to be an initiative in November about that. There's been 2 versions of initiatives submitted to the Attorney General's office, and then after that, if they qualify it by getting enough signatures, it will be on the ballot in the November election, and then you all will have a chance to decide if that cap gets raised or not. I would urge you to vote no on it. I suspect some other folks would feel differently. But those are the reasons behind. That's why we're talking about this.
Caryn, as a practitioner, any views on this?
with the medical malpractice, yes, the other recoveries may have gone up, not in accord with the rate of inflation. However, that's because the average rate of salaries has gone up in a lot of fields more than inflation. So it's not that the people are getting more, they're just getting the same amount by virtue of the cost of medical care has gone up far more than inflation. So you're paying their medical bills. So there's the big spike there, is the cost of the medical care that these people have had to have and will have to have in the future. One of the biggest problems with medical malpractice actually resides with the insurance carriers, with the medical boards. You wanted to know lawyers. Is there not more policing of lawyers? Well, the medical board has increasingly policed the doctors, where they used to be able to settle a medical malpractice case and kind of nobody would know about it. Then they decided that they had to report, at least while I've been practicing, the reporting limit was anything over $29,999. So anything over 30 had to be reported to the medical board. So if you settled any case over $30,000, you had to report to the medical board. They then changed that to 0. So if you settle a case for anything, so minor medical malpractice now is not being settled, it's being litigated because they can't settle it. They will take a chance of a defense verdict in order to not have that reported on their license. The other issue with medical malpractice is the insurance. The premiums are still going up regardless of the cap, and insurance policies are now written where they are what's called a consent policy. It's one of the only fields where there's a consent policy, and that means that the insurance company can't settle for the doctor. The insurance company must have the doctor's consent to settle, and the doctors are not giving consent. So therefore, these cases are being litigated more than they need to be. So it's actually a combination of the two. It's their own profession, their own insurance carriers that are driving the medical malpractice litigation. They're driving the medical malpractice litigation up because everything is being litigated. And unfortunately, with the cap, notwithstanding what Kim has said, there are fewer and fewer attorneys taking medical malpractice cases. They will only take a medical malpractice case if it is very large. And that is because most of them work on a contingency. And unfortunately, with the cap of $250,000, if you can't reach that cap, you don't get very much in the way of compensation. And unfortunately, I've had to tell some of my clients who have come to me with medical malpractice cases that, okay, well, now their little finger doesn't work. And I said, well, yeah, it's really bad that your little finger doesn't work. It's horrible that your little finger doesn't work. But if you're paralyzed and you get $250,000, I can't promise you, which I can never promise anybody anything, but I can't even say that there's a likelihood that you're going to get a decent recovery when what's a finger worth when paralyzed is worth $250,000. So it's also an access to justice for the people who have smaller medical malpractice cases that come into play as well. There's another issue that with tort reform that you very rarely hear about, and that is sue everybody. Sue everybody because somebody will pay you. They'll pay you to get out. They'll pay you to settle so they don't have to pay their lawyers. It happens in medical malpractice cases. It happens in all kinds of cases. Medical malpractice, they sue every doctor, every nurse, every hospital, every caregiver, regardless of whether they can make that link. And yes, there are procedures. There's summary judgment. There's demurs to get these people out. But they're still paying their lawyers tens of thousands of dollars, if not more than that, to get to that point. And there used to be malicious prosecution actions, abusive process actions, where you could then turn around and sue these people for suing you. And yes, that's more litigation, but it had teeth. And you didn't sue people that you didn't absolutely think had merit in advance if you had the possibility of having a repercussion for that. I've got clients, I represented a client who was sued for an automobile accident. They were standing still because they had the bigger pocket than the person who hit them. And they knew the longer they could keep them in the case, the more likelihood there would be that they would settle. and they would settle and they would pay something. That, unfortunately, is another aspect that people don't look at. And that is how, yes, it's frivolous, but at the beginning, maybe it isn't. Maybe you could say, well, they shouldn't have been stopped there. But once you get those facts, you need to dismiss these people and not hold, I can't think of a better word, it's extortion. Hold them in there until they settle to be removed. And there's really no means, unless we put malicious prosecution, abusive process, or some other type of teeth, to stop suing people that really didn't cause the problem.
You could give judges
hold on.
tools.
Yeah. All right, so Lisa, hold on for a second. We've got about 4 minutes left in this panel. So what I'd like to give each one of you another minute or so. You can either respond to what Caryn said or give some closing thoughts. So Lisa, why don't we move to you?
We still have, you can still bring a malicious prosecution action. So, and I have done that. And there's, there's also ways, I mean, attorneys are regulated. For example, if they get sanctioned for bad conduct, it's sent to the state bar. They can look into it. I mean, there are other mechanisms. I did want to talk a little bit about the medical malpractice issue and just go back to my example. So, for example, you kill my baby, and the medical bill for you doing that for the surgery was $1,000. Insurance paid for the rest. So the most I can recover from this doctor who was drunk or on drugs and killed my baby would be $250,000. Or you killed my husband because you were drunk, because you left the sponge in the person's abdomen, what have you. The most that I can get for that is $250,000. That's a 30-year-old law. It's old. It needs to be increased. There has to be a cost of living increase in that, because I just think it's downright criminal. I hope that we can, on whatever side of the fence you're on, that we can continue to have a dialogue and work on these issues. I think what there really needs to be, it's not tort reform, it's insurance reform. I believe that we are all getting hosed by the insurance companies. I pay for my employees' insurance. I never go to the doctor, ever. I mean, when I get my life insurance, they're like subpoenaing doctors and hospitals. I don't go to the doctor. Why are our rates going up? It's not because of medical malpractice suits. It's because they can. The insurance industry is completely unregulated. You can talk to Dave Jones about that.
Okay.
And that's what the real issue is. Thanks.
Kimberly?
This was fun, and I actually think there's some areas of common ground here, and I would welcome Richard, Lisa, Caryn to continue the conversation offline, and we'll get reasonable common sense legislators like Assemblymember Gatto to try to do some things to solve the problem. For the rest of you, if you'd like to be kept informed in terms of what's going on in Sacramento on tort reform issues, I gave you a piece of paper, and if you give me your email, we'll send you email notifications about stuff that is going on. If you don't, no problem. But if you want to give it to me, not VICA, because my organization is the one who does it, and I'm happy to talk with anybody else afterwards. Thank you to Coby and VICA.
All right, except for me, Assemblyman, you get the last word.
All right, well, thanks again, everybody, for being here. As the legislator on the panel, I will just say that, I always remember that I am here to serve you. So if you have any ideas on anything that we discussed today, any ideas for legislation, anything that should be changed, or a regulation that should be taken off the book, or a law for or an idea for a new law, send me an email. I made a rather stupid promise when I was first running for office that I'd read and answer every email, and I actually do. So if you go to any of my websites, I have both a political one, MikeGatto.com, and a government one, which is asm.ca.gov/Gatto, and you click on the send email link. It comes directly to me. I will read it, and I will get back to you. So thanks for everything, and look forward to your ideas.
All right, fantastic. Well, that is all the time we have. I want to, again, thank our panel sponsor, CJAC, as well as our track sponsor, Walmart. Thank you.